Good morning, everybody, and thank you all for taking your time out of your day to join us. My name is Lindsay Bicknell, and I'm with Utah Business. I am pleased to welcome you all to today's webinar, hosted by our friends at Maschoff Brennan, where we'll be talking about who actually owns your company's intellectual property. Joining us today from Maschoff Brennan is Mikhalev, who will be giving us the best practices every Utah business owner needs to know in order to make sure you or your company or your organization is protected. Before I turn it over to Mike, I do just want to let all of you know that we will be holding a Q&A session towards the end of today's webinar. So if you have any questions, let us know by typing it into that Q&A box on your screen. And we'll also have a video of today's webinar available on our website after we've finished, so you can come back and watch it again later if you have any more questions. All right, Mike, I'll turn it over to you.
Thanks so much for having me. So a little bit about myself. My name is Mike Mikhalev. I've been a patent attorney here at Maschoff Brennan for 8 years. Maschoff Brennan is a Utah-based law firm with offices in Salt Lake, Park City, and Orange County, California. We have about 50 attorneys, all of which specialize in IP law. About half of our attorneys focus on IP litigation, and the other half focus on obtaining IP rights and related transactional matters. So today we'll be talking about the types of intellectual property, including copyrights, trademarks, patents, and trade secrets, and then who owns these rights, because by default, the law specifies who owns these rights, and they are different for each type of right. And then also best practices to make sure your company owns your IP and that you have a good record of all that. Okay, so now we'll be getting into the types of intellectual property. First, copyrights. Copyrights are original works of authorship fixed in a tangible medium. Fixed in a tangible medium may sound like legalese, but what it really means is embodied in something you can hold. For example, you might have an idea for a screenplay floating around in your head. You've been brainstorming it for months, maybe even years. Do you have a copyright? No. But as soon as you write down that screenplay on a piece of paper, you have a copyright. What about, for example, if you type it on your computer? It exists on your laptop or in the cloud, but it doesn't exist in a specific location. Do you have a copyright? Yes, you still do, because your work does exist on a physical memory chip somewhere in the world. Whether it's on the memory chip in your computer or at a server facility thousands of miles away, you do have a copyright, and it is fixed in a tangible medium. There's all sorts of ways that works can be fixed. For example, a copyright can be created when a person acts out their work. So even a mime acting on the street corner can create a copyrightable work when they perform, because they are fixing the work in a tangible medium by performing it. Copyrights can include literature, music, drama, pantomime, choreography, pictorial, graphic, and sculptural works, motion pictures, and other audiovisual works, sound recordings, and architectural works. Also, computer programs can often be copyrightable. Copyrights give you certain exclusive rights regarding your work. And those rights are the right to reproduce the work, prepare derivative works, distribute copies of your work, and perform it publicly. For example, in the case of a screenplay or a mime. To display the work publicly and to perform the work by means of digital audio transmission. And that may sound also like legalese, but that's a radio performance of music, Spotify distributing music, things like that. There are limits to copyrights. You cannot copyright facts, data, or basic info, but you can potentially copyright the way it's presented. So for example, a news article about a current event, the basic facts behind that news article cannot be copyrighted, but the way that information is presented can. So copyrights generally last the term of the author's life plus 70 years, so a pretty long time. There are exceptions for joint works and for works that are created by companies, but in general, 70 years. These rights are created The most valuable rights are created at the time the work is fixed in the intangible medium. So as soon as it is fixed, immediately. But then additional rights are created when you register your work with the Copyright Office. Rights to copyrights can be assigned before the work is created. So for example, if you hire or if you ask an employee to create a computer program or a contractor to create a computer program for your company, you can agree to assign the rights to that computer program before it is created, and then you would have copyright rights assigned before it is created. Moving on to trademarks. Trademarks are marks or trade dress used on goods or services. Importantly, it designates a source of origin of the goods or services. Examples of this include company or product names, logos, slogans. But there are exceptions to what can be trademarks. For example, trademarks cannot be descriptive. For example, you cannot get a trademark for bicycle brand bicycles. Why? It wouldn't be fair to everyone else that makes bicycles. And it doesn't do a good job of identifying the origin, because bicycles can come from any number of manufacturers or companies. You also can't get a trademark for deceptively misdescriptive marks. So what does deceptively misdescriptive actually mean? It means the mark is lying in its description. For example, say you're a potato farmer. You can't call your product Portland potatoes if your potatoes come from Idaho, like all good potatoes do. When you have a trademark, the right you get is the right to exclude others from using your mark or confusingly similar marks. And that's important because a lot of times logos or company names can be somewhat similar. And if they're confusing enough and close enough, then you can stop somebody from using similar marks as well. Unlike copyrights, which have a limited term, trademarks can last theoretically indefinitely. Trademarks last as long as the mark is used, has not become generic, or been abandoned otherwise. But if you register your mark with the USPTO, there are renewals that are required every 10 years. Trademark rights are created as soon as a good or service is sold with the mark without registration. But those rights are generally local and limited to the areas that you use the mark in commerce. Much greater additional rights are created when a trademark is registered with the USPTO, and those rights are nationwide. When you register a mark with the USPTO, they examine the mark, search for similar marks, and make a determination whether your mark is confusingly similar to other marks. If you successfully go through this process, you can obtain nationwide rights to exclusively use the mark. Some states also individually permit you to register trademarks at the state level, but generally, these marks are not examined, so there's no indication on whether your mark is confusingly similar to others. And also, state rights are very limited and limited to the location where the mark is registered. So very few companies and businesses choose to pursue state registration. In general, almost everybody chooses to go the federal route and get a federal registration. Trademark rights are created as soon as the mark is used in commerce. And your use must be first and must not be confusingly similar to other marks. There are types of USPTO registrations that are called intent to use applications, which create some certain rights before a trademark is actually used in commerce with certain goods or services. These can be viewed as a placeholder application because to actually get rights granted, you must actually begin to use the trademark in commerce. So this is merely a temporary step when you plan to use a mark in the future. So when can these rights be assigned? So unlike other IP rights, a trademark assignment must assign the goodwill associated with the mark. So you cannot just simply assign a logo to somebody else. You must also assign the goodwill and what that logo stands for. If you don't do so, the assignment is invalid. It's considered a naked license and cannot be enforced. So since you need a goodwill to assign a trademark, you cannot assign a trademark before a trademark is used. And then in terms of trademarks, ownership issues typically are not a concern because the company uses trademarks rather than individual employees. So moving on to patents. Utility patents are new and useful process, machine, manufacture, or composition of matter. So these are your inventions and high-tech technology that your company develops. Also, there are other types of patents, design patents, which protect new, original, and ornamental designs. So utility patents can be considered useful things that do something, and design patents protect the appearance or how something looks. So one example of a famous design patent would be the shape of the iPhone, which doesn't protect what it does, but just the way it looks. And presumably there is some economic value or on the shape of the iPhone and why people would like to buy it. So patents give you the right to exclude others from making, using, offering for sale, or selling the patented item. Patents last, for utility patents, they last for 20 years from the date of filing the application. And in the case of design patents, your rights last for 15 years from the grant date of the design patent. So compared to trademarks, which last indefinitely, and copyrights, which last for 70 years, your rights are much more limited. But in a lot of ways, your exclusive rights may be a lot more valuable also. So rights are created at the time of filing an application. And those rights include the right to use patent pending and back damages. But the most valuable rights are created when the application is actually granted, because you have the ability to enforce your patent and exclude others from using the invention. Rights to patents can be assigned way before an application is filed, at the time the invention is conceived of by the inventor. So the last common IP right that we're going to talk about today is trade secrets. Trade secret is any information that derives value from being secret and is also subject to reasonable efforts to maintain its secrecy. Trade secrets can be formulas, patterns, programs, methods, financial data, business data, economic data, customer lists, business plans, competitive analysis. Almost anything can be subject of a trade secret as long as it's not publicly known and is subject to efforts to maintain its secrecy. Similar to trademarks, trade secrets can potentially last forever or indefinitely, but they must be maintained secret. And there are exceptions to that. So for example, once the secret is out, you don't have a trademark or a trade secret anymore forever. You might be able to sue for monetary damages for disclosure of the trade secret, but you are not getting the trade secret back. For example, if a former employee takes your trade secret and goes to one of your competitors and discloses the secret, you might be able to sue your employee for millions of dollars, but you're not getting your trade secret back. And in some cases, your employee likely doesn't have millions of dollars to pay you. They'll simply be insolvent and you will not really have a remedy for maintaining your secret. If your competitor, there's also an exception if your competitor reverse engineers your trade secret. You are allowed to independently develop the technology subject of a trade secret, and that's okay, as long as they do not use improper means to obtain your trade secret. So rights are created as soon as the information exists. There's no registration that is needed, but you do want to keep records of your trade secret. And most importantly, you want to keep a record of the steps you take to maintain the secrecy of the trade secret. because that would be important in a lawsuit for trade secret misappropriation. Trade secret rights can generally be assigned before the rights are created. So for example, if you ask one of your employees to create a customer list of potential clients that you want to pursue for marketing, you can agree that your company will own that customer list once the employee creates it. And the same applies if you hire a third party to do a business analysis. You can agree that the work product of that business analysis be owned by your company and is a trade secret. So software is a mix of IP rights and includes aspects of patents, copyrights, trade secrets, and trademarks. For example, you can obtain a copyright for your software in the original source code and object code. You can even register this with the Copyright Office by mailing a sample of the code, and they will maintain that registration. In some circumstances, you can also obtain software patents. They must be novel, non-obvious processes and methods, and are also subject to some statutory subject matter limitations because they have to be tied to specific computer methods. Also, there's the ability to have trade secrets in your software. As I mentioned before, it needs to have economic value and reasonable efforts to maintain secrecy. But in some cases, it may be difficult to protect your software from reverse engineering. So, as a summary of types of IP rights, patents cover a scope of protection for inventions. You have a term of 20 years, and there's an application process through the USPTO. Copyrights protect creative works. The term lasts for the life of the author plus 70 years, and you may register your copyright with the Copyright Office to add protection. For trademarks, it protects company branding and is potentially indefinite. However, there is a 10-year renewal at the USPTO, and you may register your mark with the USPTO for significantly increased rights. Trade secrets protect any information, such as business practices. The term is indefinite, and there's no application process for trade secrets. So now we will talk about who owns these rights. So for copyright ownership, the author gets ownership immediately when the copyright work is created, and it goes to the author, not the company, except in the case of work for hire. Authors of a joint work are co-owners of the copyright. So if there's multiple authors of a work, which there often is, they'll be co-owners of the copyright. So for example, if you have multiple people participating in a project that will be copyrightable, you would need to get assignments from each of the authors of the work. Copyright does have something called the work for hire doctrine. And the work for hire doctrine says an employer gets ownership of a copyright immediately when the copyrightable work is created by the employee. But it must be work prepared by an employee within the scope of his or her employment. So issues arise when you determine what is the scope of employment, whether what the employee did was within that scope. And then there's also issues if you hire contractors to develop a copyrightable work. Since you have less control of a contractor and they're not employees within your company, you won't necessarily qualify for the work for hire doctrine. So moving on to trademark ownership. Trademark rights are created as soon as they are used in commerce. The owner is whoever first uses or registers the mark in connection with certain goods or services. So oftentimes, the owner of a trademark will be the company or business because individual employees do not use the mark in connection with certain goods or services. However, ownership issues do arise in connection with other companies using the same or similar marks. Employees, contractors generally do not try to steal a company's trademark when they move on or when they leave to other positions. However, the control of trademarks generally corresponds to the control of the company, because the company owns a trademark. Patent ownership. Inventors or joint inventors get certain rights as soon as the invention is conceived. So that's when the invention is made up in the mind of the inventor. Unlike copyrights, they do not need to fix their invention in tangible medium. It can exist in their mind alone. One of those rights is the right to file a patent application with the USPTO, which will eventually lead to exclusive patent rights. There is no work for hire rule for patents. So employees are not presumed to have to assign their rights to their employer. And that means employers have absolutely no rights unless the inventors assign rights. And this is very important. Trade secret ownership. Anybody who has valuable information and takes steps to keep it secret. There's also no work for hire rule for trade secrets. For that reason, ownership of trade secrets may be unclear unless employees assign those rights. The hardest part is often delineating what is a trade secret and what is not. Generally, employees are presumed to be able to take their know-how with them to their next employer. So your employees will generally learn things on the job about how to do their job. They might learn a certain way of coding software or gathering business analysis or something like that. It's difficult to define what is a trade secret and what is general know-how that they have learned in connection with their job. So it's important to specify what the company considers is their trade secrets and clearly delineate that as confidential. So as a summary, the default owner of patents is the inventor. The default owner of copyrights is the author who created the work. Default owner of a trademark is generally the company bearing and using the trademarks. And the default owner of a trade secret is the company using the trade secrets. So now we'll be talking about some best practices for IP ownership. So the most important thing to do to protect your IP as a company is to include an IP assignment clause in all employment agreements. You want to make sure the IP assignment clause covers all IP rights that you were contemplating. And in some cases, you will want to make sure that inventors of patent applications will cooperate in prosecuting patent applications. And I'll talk about that a little bit more later. One of the hardest things to do is to make sure that all employees actually sign the employment agreements and record keeping. Keeping a record of every signed employee agreement as proof that that your employees have assigned their IP rights to the company. In some circumstances, this will be difficult because it is a large amount of data and the data must be backed up and secured. So some companies choose to rely on law firms or other third parties for data management, so they don't have to worry about that themselves. So there's lots of different options for IP assignment clauses in employment agreements, but here's one example that you could potentially use. So patents have specific considerations for best practices. Number one, you want to have an IP assignment clause in employment agreements. You want the assignment clause to assign rights to any patent applications or patentable ideas that the employee comes up with in the course of their employment. Assignments are also going to be executed when each patent application is filed, but if you already include an IP assignment clause in employee agreements, then employees are already obligated to assign these rights, so it does not actually change their rights. And employees will also be more likely to execute those assignments in those circumstances. Also, you may want to require employees to cooperate in prosecution and sign documents, even if the employee departs to work somewhere else. So the patent process can take 1 to 2 years on average. During those 2 years, between the time that the employee has conceived the invention and the application is filed and is prosecuted before the USPTO, the employee may depart to work somewhere else. And at that time, they may not be as inclined to cooperate in the prosecution process or assist in doing paperwork or providing information that may be required for prosecution. However, if your employee agreement specifies that they must cooperate in the prosecution process, even if they depart, that could be hugely advantageous for a company and may encourage the employee to be helpful, even if they no longer work at the company. There's different assignment forms, but the USPTO includes a standard declaration and assignment form that can be used for patent assignments, and that can be filed along with the patent application. Or you also have the opportunity to use custom assignment documents. The USPTO has a process where assignments can be recorded. So this is a database that the USPTO maintains that's a record of all patent assignments and related patent rights. It's not required, but we highly recommend that an assignment be recorded with the USPTO at the time of filing. And this does also ease the record keeping burden of a corporation or a company, because once that information is recorded with the USPTO, they are maintaining that information and database rather than you. Also, some companies use information disclosure forms, which is used at the beginning of the patenting process, where the inventors first disclose their idea to permit the company to decide whether they want to file a patent application for the idea. And many companies now have become including an assignment provision in the invention disclosure form that they require employees to sign. And this gives you an added layer of protection because it's so early in the process. Even if the employee departs later on, you have a recorded assignment of the invention, which is extremely helpful. So there are potential ownership issues for patents, and the biggest one is non-cooperating inventors. So when employees depart and leave for another job, it is not always on good terms. In some cases, they may be fired or leave for some other disagreement with management. And at that point, they're much less inclined to assist the company that they used to work for. As I mentioned, inventors can leave the company at any stage in the patenting process, but if they do so, it may complicate the process. Also, it is important to think about who is properly an inventor. So an omitted inventor can sue to be added to the patent, which in turn may cause an ownership problem. A company can also file a patent application for technology it doesn't own. So if, for example, you hire a contractor to prepare some sort of technology and you do not include an ownership clause or an assignment clause in the agreement with the contractor may properly own the technology and may own the rights to file the patent application. However, a company can file a patent application and spend thousands and thousands of dollars on prosecuting the technology for a technology that it does not legally own. And that would be a huge waste of resources and a difficult position for the company to be in. Also, ownership issues often arise when a company purchases patents from another company or when it acquires a company. So maybe you have your business in order and you have assignment provisions for employees within your company, but potentially the company that you're acquiring or the patents that you purchase, the company was not as careful, and then you have issues with ownership of the patents that you acquire. So for that reason, companies do their due diligence and review the assignments and ownership documents of IP that they acquire before they actually complete the deal. Best practices for copyrights. So as usual, you want to include an IP assignment clause in employment agreements. It needs to cover copyrights as well as the other types of IP. You also want to be careful in identifying potentially important copyrightable works created by employees. whether it's software or other types of work. And you want to register copyrighted works with the Copyright Office because of the increased rights that you obtain when you register those works. Best practices for trademarks. As I mentioned before, usually there's no disputes in ownership with employees or contractors. A departing employee will likely not try to use your trademark when they leave or go to another employer. However, purchasing trademarks or acquiring a company with trademarks, you must make sure that you get an assignment of goodwill along with trademark rights. Often the only case where ownership issues arise is if the ownership or control of the company comes into issue and there's a dispute about control of the company and trademarks. So for trade secrets, it's really important to distinguish trade secrets from disclosed business practices or publicly available information or other training or information that your employees may acquire as they learn how to do their job. Companies need to develop a trade secret protection protocol. You need to train employees to properly manage trade secrets. You need to mark information that's confidential as confidential. And then the most difficult thing of enforcing a trade secret protection protocol is sticking to the plan and making sure everybody complies with the plan. You also have the opportunity to utilize contracts to protect trade secrets. Whenever you're cooperating with parties outside of the company or disclosing trade secrets or other valuable information, you need to include confidentiality and non-disclosure provisions. You can also use non-compete agreements or non-disclosure agreements for employees. That way, if an employee leaves to go work somewhere else, they may be departing with know-how or trade secrets, and probably both. But you need to specify what information is a trade secret, what is confidential, and what is know-how that's okay to use. In some circumstances, you could have non-compete agreements in your employment contracts, and that prevents an employee from working for one of your competitors or somebody closely positioned in the field that you operate in. These types of agreements can protect trade secrets, but they're also severely limited in employees' ability to find work. So if, for example, an employee has been operating in a field for a decade, they may have learned how to do their job really well, and a non-compete agreement can prevent an employee from working somewhere else, and that might stop them from being able to find a job in the first place, or starting from scratch in a different career. For that reason, state law often severely limits non-compete agreements with different requirements in each state. For example, in California, there's huge limits on non-compete agreements, and in most circumstances, they are unenforceable. Utah, however, is more favorable for non-compete agreements and does allow them in certain circumstances. So say you want to partner with another company to develop a new product. You may want to engage in a joint venture with this other company. So both companies will be working together to achieve a goal or develop a new product, and each one will be bringing something to the table. So what are you bringing to the table in a joint venture? It's important to clearly define all IP involved in a joint venture: patents, trademarks, copyrights, trade secrets. So both companies will have some IP that existed prior to the joint venture. And a contract with another company must specify who owns this IP, existing IP rights. Also, who pays to procure rights in the joint venture. Somebody has to pay for trademark registration, copyright registration, and patent prosecution. We need to specify who is going to pay for procuring rights in joint ventures. Also, we need to figure out who is going to own IP that's created as part of the joint venture. The joint venture won't necessarily last forever. And if the parties split, you must specify who owns the IP and perhaps who has a license to use the IP if necessary. Also, existing and newly created trade secrets will be shared. And as I mentioned, for trade secrets, it's important to take measures to keep the confidentiality of the trade secrets. So both companies will need to specify mutual obligations to maintain confidentiality. As I mentioned, joint ventures do not last forever, so the contract needs to have an exit plan strategy. And that needs to specify provisions for protecting IP after the joint venture dissolves and maintaining some certain obligations that must survive after dissolution of the contract. In general, ownership issues often arise when companies are starting out. Early stage business partners or contributors often give rise to ownership issues. As mentioned before, departing employees also create ownership issues, and it's important to handle those before an employee leaves. And properly identifying creators of IP for ownership is vital. For example, inventors can be added to the patent after they realize how valuable the patent is, and you want to make sure that the correct inventors are included at the time a patent application is filed. So in conclusion, identifying your IP is the crucial first step for protecting it. Knowing whether something should be protected by copyright, patent, trade secret, or trademark is very important in the steps of protecting it. Employment agreements are the cornerstone of IP protection. Every company needs to have a detailed employment agreements that each of their employees sign, and these employment agreements must have an IP assignment provision. Also, record keeping and data management of your IP is important to make sure it's properly protected. In some circumstances, you can rely on third parties or law firms for record keeping, data management, and making sure your IP is protected.
Okay, thanks, Mike. We do have a couple of questions if you're ready for the Q&A portion of our webinar today.
Yeah, definitely.
All right, so our first question is from Carolee. She asks, is it possible to sell and license trade secrets?
It is, definitely. So just because a trade secret must be confidential does not mean it cannot be disclosed to others and sold, as long as there are provisions to maintain the trade secret and confidential. So you are able to share it with other parties, just not enough parties that the trade secret is lost or publicly disclosed.
Okay, and then a follow-up for that question. She asks, can I obtain a patent and keep my company's invention secret?
So let's see. So a requirement of patent law is that you sufficiently disclose your invention for someone skilled in the art to make and use the invention. So there are certain disclosure requirements that exist when you obtain a patent, but there are certain things that can still maintain a trade secret even if you file a patent application. For example, the minute details of implementing it or something like that.
Okay, Vicky asked if we can have a copy of the slides and the recording after this is all over. Vicky, we will have the recording available on our website, and I'm sure Mike would be happy to share his slides, but I will let him take care of that. If we have any other questions, go ahead and type it into that, either the chat box on your screen or the Q&A chat, and we'll answer that because we do still have some time. It looks like Vicky has another question. If you have a similar product to another's without knowing their secret sauce, but it does the same protective coating, can it be granted?
So let's see, it sounds like you might be talking about a patent. So if you independently arrive at the same secret sauce or the same invention as somebody else, the person who conceived of the invention first gets the rights. So if you came around second and came up with the same secret sauce you would not be able to get patent rights. But in the case of trade secrets, two companies could have the same trade secret and can proceed in operating, both maintaining certain rights. Okay, so it sounds like she was talking about trade secrets. Yeah, so two companies can. So as I mentioned, first of all, there's no grant for trade secrets. A trade secret is maintained as long as you keep it secret. But yes, both companies can have a trade secret for the same secret sauce, and potentially would not even know about the other company's use or knowledge of the trade secret because it is maintained secret.
All right, another question from an anonymous attendee. Any suggestions on successfully managing joint ownership of IP in a situation like a joint venture?
Yeah, so as I mentioned before, identifying the IP that's going to come into play is very, very important. Also having a contract that specifies what IP exists before the joint venture, what IP is going to be developed during the joint venture, and who's going to have ownership of the IP during the joint venture and also when the joint venture dissolves.
Okay, this question comes from Matt. Do you have the same trademark protection if you use a superscript T on a logo or trademark word or name as you have with a registered trademark?
So it sounds like you might be talking about the TM symbol. So the TM symbol means that you are treating a logo or a company name as a trademark. So that does not mean that you have granted rights with the USPTO yet. So when a trademark has the R symbol with a circle around it, the registered trademark symbol, that means that you have a registered trademark with the USPTO, and the only certain time you're allowed to use that is when you have a registered trademark. But a TM logo just indicates that you are treating this logo or company name as a trademark, but you have not registered it yet. So the R logo is basically more powerful and a more important symbol of your trademark rights.
All right, does anybody else have any other questions? It looks like we have another question from Matt. How much protection do you have with a TM?
So basically with a TM, when it's not registered, you would have to establish that you were the first person to use the trademark and you do not have nationwide rights. So you have local rights only in the locations where you make or sell the goods. So in contrast, a registered trademark gives you nationwide rights. If you're operating just in the state of Utah or just in a certain city in the state of Utah, you would only have rights there. And then things get a little bit more complicated when you sell products or services online because, you know, people from all over the country or the world could potentially see your website, but it depends on who you're actually selling the product or service to online.
All right, again, if anybody else has any questions, just go ahead and type that into your little chat on your screen or in that Q&A question portion on your screen. We have a question from Vicky. Is a patent just allowing the world, especially China, to potentially copy your patent with a few changes?
So let's see, there are disclosure requirements for a patent and a patent application. It is published, and one challenge with patent rights is they're limited to the country that you apply in. So you could actually apply for a patent in China and have rights there, and a lot of our clients do. And China in the past 10 years has gone a lot better at enforcing IP rights, including patent rights. So we have successfully enforced patent rights in China and had companies, you know, destroy products or cease producing infringing products in China. But when you file a patent application, one of those requirements is disclosing your invention fully, and that does permit people to improve your invention in the future. And the reason they want to do that is to encourage innovation. So you do get exclusive rights for 20 years to your invention, but it accelerates innovation if people are able to improve products. So you mentioned changes to inventions, and those are permitted, and improvements are allowed to be made to patented inventions.
All right, do we have any more questions from our attendees today? All right, another question from Vicky. Is the US Treasury still spending 90% of its time prosecuting China for infringements and theft?
That I'm not sure about.
It's a good question. Another question from Matt. Is a music video something you get a copyright for if there are multiple singers in the music video and it is produced by a company? Who owns that copyright?
So a music video is definitely something you can obtain a copyright for. And so if there are multiple singers in a music video, but it's produced by a company, it'd be the producer that owns the copyright to that work. The singers probably are commissioned by the company to produce a music video, and almost in every circumstance you would have the singers also sign any rights that they had, but it would probably be considered a work for hire if the singers did not come up with the content of the music video, depending on who directed and produced the video. But so joint ventures like that are very complicated, and it's always important to have contracts and assignment clauses that specify who owns them in that circumstance.
All right, does anybody else have any questions for Mike today? All right, well, it looks like we don't have any more questions. Mike, is there anything else that you want to share with our audience today before we break and get back to the rest of our workday?
Nope, I think that's it. Thanks so much for having me and taking the time to listen.
Yeah, no, thank you for doing this wonderful and informative webinar for us today, Mike. I learned a lot today. I hope everybody else learned just as much as I did. Thank you all for joining us, and be sure to keep an eye out for our next webinar. If we didn't get to your question today, or you had a question and you didn't want to ask it in front of everybody, go ahead and just shoot us a message at Utah Business, and we will put you in touch with Mike, or his contact information is right there on the screen. You can reach out to him directly as well, but we'll make sure that you get in touch and your questions get answered. Like I said earlier, this recording will be available online on utahbusiness.com, and I believe our friends at Maschoff Brennan will be sending you a link as well, so keep an eye out for that. But if there's anything else that our audience has questions about, please feel free to let us know, and have a great rest of your day. Thanks, everybody.